items, dissolutions, mergers, sales of substantially all of the corporation's assets, things like that. Shareholders do not, however, have the right to make business decisions for the corporation on a day-to-day basis. Okay? Just because they own the company, the way the allocation of power is set up, they can't make day-to-day decisions. Okay? The directors that they appoint do manage the business and affairs of the corporation. They set policy, make kind of fundamental business decisions, and then they appoint officers who carry out that policy on a day-to-day basis. Okay? Typical officer positions you'll see: president, treasurer, secretary, and I don't mean someone who answers the phone. I mean someone who is responsible for certifying the records, the non-financial records of the corporation. I see some of you kind of rolling your eyes a little bit. I will say this allocation of power gets skewed and mixed the smaller the corporation is. Okay, and so if I'm the sole shareholder of a corporation, then I'm probably going to elect myself as the sole director, and as the sole director, I'm probably going to name myself as president and any other number of officer positions. If you're the sole shareholder, who else do you want running your company other than you? But the more shareholders you get, the more important that distinction becomes between those three parties. Okay? Incorporation. Let's say you've looked at the advantages and the disadvantages of incorporation. You've decided that you do want to incorporate your business. What are the things you need to do, the steps you need to take to accomplish that? And I've listed in your outline a good kind of checklist of items you will need, and I'll talk about each of those briefly. Number one, you'll need to get a name reservation. Okay? Corporations in Alabama are required to have a unique name from other corporations that are already out there in the state. The reason being, you don't want 10 Chris's Cabinets Inc.'s out there in the state doing business. You want to differentiate those different corporations. How do you find out if a name is available? You can go to the Alabama Secretary of State's website. They have a search engine where you can type in idea names that you have for your corporation, and it will pull up, if a corporation already has that name, it will pull up that entity, or it will pull up a similar name, so you can make a judgment on whether or not that name is sufficiently distinct from one that's already out there. And if one is available, you can reserve that by either calling the Alabama Secretary of State, or there's a form you can download on their website and fax that in. And I believe right now there's a $10 fee to do that. Once you've reserved your name, you'll need to prepare or have prepared and file articles of incorporation. This is the document that is filed with the probate judge of the appropriate county, and when that filing is made, the corporation is deemed to come into existence. I will say Alabama is a little different than most states out there in that initial filing is not made at the state level. Okay? In most states, you make that filing directly with the Secretary of State. In Alabama, you'd rather make that filing initially at the county level, and then when you make that filing, the county will mark that as filed and then forward it along to the Secretary of State. And there are two fees you'll have to pay at that point, one payable to the probate office and another fee payable to the Secretary of State. Right now, those fees are $40 to the Secretary of State, and then for Madison County, $52.25. I do encourage you, though, to always call the probate office and double check those fees just to make sure they haven't changed. And if you are incorporating in a county other than Madison County, you'll need to check with that appropriate probate office to double check those fees as well. I've got down here action by written consent of Board of Directors and action by written consent of shareholders. What an action by written consent is a document that lists resolutions. Okay? Typical resolutions initially for the Board of Directors will be to appoint the officers of the corporation, to approve of the issuance of shares to the shareholders, to adopt the bylaws of the corporation and other kind of fundamental initial acts. And then similarly, the shareholders will approve the items that the directors are doing. Okay? Now, in lieu of having those documents, you can have a formal meeting of both the Board of Directors and the shareholders but a lot of times it's just simpler to do this by a document rather than trying to round up everybody to have a formal meeting. The bylaws are a very important document. The bylaws are the document that govern the internal affairs of the corporation. Typical items you will see are the date and time of the annual shareholders meeting that every corporation is required to have, the requirements and the size for serving as a member of the board of directors, and then another item will be listing different officer positions that the corporation will have and listing out what the duties of those particular officers are. Okay. You'll need to issue stock certificates. Stock certificates reflect the actual ownership of the corporation. You can think of those as being similar to a vehicle title for your car or truck, or a deed for any real property that you own. And those stock certificates will be issued to shareholders in proportion to their percentage ownership of the company. And so if you've got, if you're a sole shareholder, you've got one owner, for ownership percentage issues, it doesn't matter if you issue that person 1 share or 10 shares. In either event, they're going to own 100% of the company. And similarly, if you've got 2 shareholders who have agreed to a 60-40 split, it doesn't matter for ownership percentage issues if one person owns 6, the other 4, or 60-40, or likewise, as long as those percentage ownerships are maintained. If you meet the requirements that we talked about to be an S corporation and you want to make that election, you'll need to make a filing with the Internal Revenue Service, a Form 2553. Again, you make that election, you meet those requirements that we talked about, and you can avoid that double taxation problem. Corporations in Alabama are required to pay an annual business privilege tax, and so you'll have to make an initial business privilege tax filing with the Alabama Department of Revenue. For newly incorporated entities, there's a minimum $100 tax, and so that's probably going to be the amount that you pay the first time around. Every corporation is required to have an employer identification number, similar to a Social Security number for individuals. If you're going to set up a bank account, the bank's going to require to have a look at your EIN number, and you'll have to make a filing with the Internal Revenue Service to obtain one of those, and it's called a Form SS4. And again, you can find out more information about these on the IRS's website. One piece of documentation that isn't required, but I would definitely encourage you folks to think about if you're going to have more than one shareholder, is a shareholders buy-sell agreement. Okay? And what that document does is provide the procedures for any transfers of shares amongst the shareholders. Usually provides the corporation and the other shareholders with a right of first refusal to buy those shares back before you can transfer those to a third party. Okay? So let's say that you and I are two sole shareholders of a corporation, and I want to sell my shares to a third party. You may not know that person, or you may know that person and not want to do business with them. In the absence of an agreement to the contrary, I'm free to sell those shares to whoever I like. With a buy-sell agreement, you have the chance to buy those shares back first at that offered price, and so it gives you the ability to limit who the shareholders of the corporation are going to be, and basically limit who you're going to be doing business with. Okay, gives you some control over those matters. There will be, depending on the type of business that you form, additional items to look at. You may need state and local business licenses and permits, and there may be some other tax filings that will kind of depend on the nature of business that you're doing. At the incorporation stage, it's very important to think about some things ahead of time before you begin the incorporation process, because it's going to come up sooner rather than later. Number one, the amount of capital, the amount of money you're going to need to start the business, and then to carry that business going forward on a day-to-day basis. And obviously you can get that money, that financing, from a number of different places, whether it be contributions from shareholders or traditional bank financing loans. Ownership percentage issues. If the corporation is going to have more than one shareholder, you definitely need to think about how that division of ownership is going to be made. If you've got 2 folks, is it going to be 50-50, or is it going to be an unbalanced ownership? And obviously, the more shareholders you get, the more complicated that process becomes. Is it going to be an even split amongst the parties, or is one person going to have a larger percentage than the others? And finally, operational procedures. Who are going to be the officers and the directors? Again, the smaller that the corporation is, the easier that process becomes. But the more folks you have involved as owners, the more complicated it can be as to who's actually going to run the company. Sir, you got a question?
Incorporating outside of Alabama,
Mm-hmm.
for example, Delaware,
Mm-hmm.
seems to be a popular place. Advantages?
It is. Delaware, usually when it comes down to incorporating a business, you've got two primary choices. Number one, the state where you're going to have your principal place of business, or number two, Delaware. Okay? And the reason Delaware is so popular is, I talked about that well-established body of case law earlier. Delaware really has that. They have a specialty in the corporate area. They deal with cases all the time, and so it's easier to predict how they're going to come out on a particular issue. And quite frankly, it's more, their laws up there are more corporation beneficial. Okay? And so if you're setting up the corporation, you're going to be the owner, you want to set up in a place that's going to protect you in the best possible position, and Delaware provides that. I will say that if you have a business in Alabama and you incorporate in Delaware, which we do handle frequently, there is going to be increased costs, okay? Because when you incorporate in Delaware and your business in Alabama, you're going to have to go through the process of qualifying to do business in the state of Alabama, which is going to increase your fees a little bit. But depending on the size of your corporation, excuse me, and the type of business you're going to be doing, sometimes it is worth that extra cost and expense to go ahead and do that. It's a very good question. Let's say that you have incorporated your business, you've reserved your name, you've drafted your articles, and you filed those. What steps can you take to protect that corporate entity, that limited liability protection that you've obtained? Now, as I said, as a general rule, a properly organized corporation is respected as a separate, distinct entity than the individual shareholders. Okay? It's free to own and hold real property, to sue and be sued, to enter into contracts, and basically to carry on business as an individual would in that capacity. And it's this notion of that separate entity where shareholders get that limited liability protection. They're not going to be liable for the debts and obligations of the corporation. But as I mentioned earlier, there are circumstances under which courts will set aside that limited liability protection and hold shareholders personally liable for corporate debts. And again, that is known as piercing the corporate veil. I will say it's an extreme circumstance when that happens. Courts will often require a showing of a couple of different factors